this. I'm being joined by the president of the Nigerian Bar Association, Mr. Maikyau, who is the president of the NBA, Senior Advocate of Nigeria. He joins us live here. Thank you so much. It's good to see you.
Thank you, Sean. Good to see you again. Thank you.
Yeah, it's good to see you. Would you be monitoring the election, though?
Yeah, so we're careful the use of the word. We are not monitoring, we're observing the election. Because in observing the election, there are clearly things that we cannot do. We are only, like the word depicts, only permitted to observe. And what have we done? We have 1,020 observers that have been accredited by INEC to observe the election, and these 1,020 observers were pulled from our 128 branches across the country. All of them have been accredited. They've been trained on what to do as observers, what's expected of them. And we have also set up a situation room at the NBA Secretariat on Muhammadu Buhari Way, where we'll be receiving reports from all the observers across the country. We also have developed an application that would not only help in uploading the information that our observers are going to send to us, it would also help in the verification of the content of the information. For instance, all those forms, it's a web-based form, so where you are sending the form from, it will tell us the location. It was also, we also have a graph at the end of the day that will tell us the nature of reports that we have received. If it's the pictures, would have a graph telling us the percentage of pictures we received, and then the nature of the infractions, if any, that have been observed by our members. And we as Nigerian Bar Association, we are interested in a successful conduct of the election, and we appreciate our responsibility in the conduct of elections. That is why when we came on board, we're very clear to tell Nigerians that there is one thing that we owe Nigerians. We told ourselves, as members of the legal profession, we owe Nigerians sincere participation in the election process. And by that I mean, even as you go to the polls, you conduct yourself well as an electorate, as someone who is entitled to vote. If you participate in the pre-election matters, you also have to conduct yourself well. Similarly, the conduct of the post-election matters. There is no way you can start and conclude the elections without the participation of members of the legal profession. And so one thing that we are doing as a bar is to make a commitment to Nigerians that we would participate honestly and sincerely in order to get a free, fair, credible, and verifiable elections. And that is why we are partnering with INEC like we have always done, to make sure that we, in whatever way that the Nigerian Bar Association can support and lend its own expertise and skill in helping INEC to succeed in this bid, we are prepared to do it.
Interesting. It does look like NBA is preparing for this election as though you're taking a front role in this exercise. Yeah. How critical is this election for Nigerians?
Well, it's critical to the point that the Constitution recognizes the right of every Nigerian to express a choice of who leads him. That is how critical it is. It can't be more than that. It can't also be less than that. It's a constitutional matter. It is a constitutional right that is conferred on every Nigerian, and it is with that understanding that we are approaching this particular issue. That is how critical it is, Sharon.
If you're gauging the enthusiasm or the readiness or the mindset of Nigerians about this election, how would you rate it?
Well, it's difficult to pray into the minds of Nigerians.
But I mean, you can feel from what people say, from how they interact and all of that.
Exactly.
I mean, compared to other elections.
Well, it's not quite different from other elections. I can only say that this time around, there seems to be more awareness. There appears to be more participation. We expect to see more people troop out to go and express the choice for their leaders this time around. I mean, there are some skepticisms here and there, but by and large, people are excited. People are looking forward to the election. And I am also looking forward to something exciting for Nigeria, an election that is going to give us an opportunity to actually express our choice of who leads us within the limited scope of what we have in the Constitution. We do not have the best of frameworks to usher us into what I would consider a free platform or free atmosphere for us to express our franchise, given the constitutional framework that we have. But within that limitation, I think that Nigerians are looking forward to an exciting moment starting from tomorrow when they will troop out to the polls to elect their leaders.
Legally speaking, do you hold the view that, what's your view on the legal framework that is giving us a background into this election? How would you assess the legal framework into these polls?
Well, so legal framework, you have to look at a couple of things. How did we even get to the choice of those who would contest election on the platforms of the political parties? Why are Nigerians restricted to expressing their aspiration into any of the elective offices on the platform of a political party? Why must it be so? So you don't have an option. If Shehu wants to contest for the presidency of this country, Shehu would have to find a platform, a political platform. Why can't Shehu, if we all agree that Shehu is a good material to represent us, why can't we have Shehu without going through the bottlenecks of the political parties? And we all know what happened in the political parties, how that you have to really struggle to get a ticket. Sometimes you find someone who has been in the party for a long time having to port to go to another political party because for some reason he's not able to get that ticket on that party. So if we have people, not those who jump from one political party to the other, but on the basis of merit, and we know that when they get there, they are going to give us their best, they are going to represent us very well, they should go on the platform of the independent candidature and express that franchise. So we have that limitation going into the selection of those who would even contest.
But that's a constraint. It's a constitutional provision.
It is a constitution.
Which the Constitution says you must be a member of a political party.
So it's also a limiting factor. I consider that a limiting factor is a legal framework. Why is it that we should have so many cases go to court if they have to do with disputes between members of the political party? It clogs the courts. This time around, under the Electoral Act 2022, all the matters that should have been heard by all the courts, Federal High Court, State High Courts, and FCT High Court, are now concentrated on the Federal High Courts. So if you had about 700 judges that were supposed to attend to these matters, now you have just about 78. That is, should all the judges of the Federal High Court attend to the pre-election matters. That is up to something that we need to look at. We also need to look at the points where some election matters should stop. Why must certain matters go all the way, even pre-election matters go all the way to the Supreme Court? The Supreme Court, in the last couple of maybe weeks or months, have been delivering for every judge, maybe delivering 10 judgments. That is taking a great toll on the court. So many other cases are suffering.
And so, you have people who have their cases pending in the Supreme Court for upward of 2 years.
Exactly.
And not being heard.
Exactly. So, and those cases
but
are
is the
important.
NBA doing anything about this? I mean, in the first place, this may be a little diversion, but I mean, it's as important as part of, as the conversation we're having. The Supreme Court is not absolutely constituted, and a few other courts also are complaining about the constraints that they have in terms of the workload on the judges.
Exactly.
What is the intervention of the NBA?
So we have in several fora called on the executive, because now that bit also rests with the executive to make sure that, for instance, the full complements of the Supreme Court is 2021. We have just about 13 justices. Some of them would be retiring. And so even if we have the full complement of the court, it will still not deal with the issue. So we are asking for some constitutional amendments, either to remove certain things, certain matters from the jurisdiction of the Supreme Court so that it stops either at the Court of Appeal. In fact, I had cause to also advocate for the constitution of a constitutional court that would deal squarely with matters, electoral matters of this nature. So it becomes a specialized court. It's a court that is standing on its own. I mean, it's not just going to come on board
just like in
on
the
ad hoc
industrial
basis.
court or,
Industrial
or
court.
special arm of
Exactly.
yeah.
So we can sit down and agree on what sort of matters should go to that court. So you reduce the matters that go to the Supreme Court and allow them, as the policy-making court that they are, to continue to drive the policy of this country within the ambit of the law. That way, I believe, is going to reduce the workload and also make it a lot more easy for us to be able to.
But how is that process that you're thinking about? How is that going, though?
Well, I mean, when I came on board, even before I came on board as president, I had made some with the constitutional amendment process that went on with the 9th Assembly. I participated. I did submit a representation asking for some constitutional amendments, and that also included these aspects that we are talking about. And I know that there has been this call on government to do that. So we would continue to push for the constitutional amendments that we require, the amendments of the law in terms of the subject matter that goes to the court, maybe in terms of the creation of a special court to attend to these matters, and all that we need to do just to make sure that we create a healthy atmosphere whenever we have a conduct of election. I mean, certain electoral jurisprudence by itself seek to discourage litigation. So we must take advantage of our laws to make sure that we drive that into the consciousness of the political gladiators, so they begin to accept the result, and that way we begin to have less of heating up of the polity.
Yeah. Is Beavers the game changer?
Well, yes, Beavers is a game changer. It's a game changer to the extent of the premium that the law has placed on Beavers. Yes, we've seen what happened in the Osun election, and you would permit me not to dabble into so much of Beavers, because this is something that is still sub judice. But suffice to say that it's a game changer, because we have in the law that where the device fails to work, then that election should not hold. So to that extent, it's an introduction. It's an element that has come into our electoral jurisprudence that has, with that effect of not letting an election go on, or postponing the election because Beavers does not work. So it's a game changer to that extent, and maybe because of the other issues that are pending in court with respect to the application and the use of Beavers, you would permit me not to speak beyond what I've just said. But yes, to answer your question straight away, Beavers is a game changer. It's a device that helps in verifying who the person who has approached the polling unit or the electoral officer is, whether he is actually the person who is entitled to cast that vote at that place. Is he the person that he claims to be? So it's a process, it's a device that helps in the credibility of the process, because one man, one vote is what Beavers that has been introduced seek to achieve. And I believe that, yes, to that extent, it's a game changer.
Does the Beavers or any technologies that need some a double coating or a tougher layer of protection of the law in the Constitution? For now, the issue of technology used in our electoral process is just guided and protected by the electoral law. Do you I mean, what's your view on the position of the Constitution, and perhaps maybe there is a need for a Constitution to state on how far technology can go in our elections?
Well, Shewun, the Constitution as the ground norm, it's not supposed to contain every detail that we need. It simply gives a guide. Now, it must not necessarily talk about the use of technology for the purpose of the conduct of an election. What is this technological device what does it intend to achieve in the process? If it can serve the process of bringing credibility, and it will help in the integrity of the process. And by the way, we are in a world today where even without mentioning it in the Constitution, we know that we have to embrace technology. It has become a way of life for all of us. I mean, to get it right, you have to deploy technology in virtually everything that you are doing. So I think it would suffice if we have it expressly mentioned in the Electoral Act and the extent to which we should use any technological device in the conduct of our election. If it is clearly stated in the Electoral Act and accepted as a basis upon which we can also test or verify the integrity of the process, that for me would suffice. But of course, there is nothing wrong in putting it in the Constitution. But I just said this to say that not everything must be in the Constitution, but then we have enough provision in the Constitution to give a support should the Electoral Act decide to make Beavers or any technological device clearly a part of the electoral process, and even makes it mandatory that it has to be used. But of course, maybe before that is done, even the legislature would have to consider our practical realities. I mean, do we have the necessary infrastructure upon which we can build or place the use of this technology in the conduct of an election, looking at the literacy level in the country, and then the accessibility to this technological
internet
platform.
penetration.
Exactly, and internet power, for instance, is also very important. So these are all infrastructural issues that we have to deal with. Otherwise, the law would not even make any sense.
I mean, in fact, a lot of people have argued, those of the school of thought, that the INEC has been given as much power that is general enough to be able to act. I mean, it's stated as much that INEC is granted the power to do what it thinks can make the election go well, and I mean, employ or deploy such things that will give the election integrity. But for the electoral law, Mr. President, how rock solid do you think that law is? It's going to be put to a very general test. We've had specific use of the law in Osun and Ekiti, but this is going to be a general test for that law in a general elections.
Yes. Shaun, so it's a 2020 Act. It has come with lots of innovations. I mean, the first of the test was in pre-election matters, and for a post-election matter is the election in Osun. And so we are waiting. I know that the courts and the judges that have been deployed to deal with post-election matters have been undergoing trainings. And in most cases, it is when you put the law into test that you actually appreciate the import of some of the provisions, why those provisions were inserted there. But it's also not difficult to pray into the reasons, because we had the 2002 Act and then subsequently the 2006 Act. We also now came and graduated to the 2010 Act. All of these subsequent amendments that happened, let's say from the 2002, of course, we had the previous, even the electoral decrees that ushered in the 1979, maybe 1977 decree that did that. So it's always in the use of the law that you discover that certain gaps are in that law, and you need to make an amendment of the law to deal with certain mischiefs, that you have identified in the previous laws. So you can see that happen between the 2010 Act, Electoral Act, and the 2022 Act. And that is why some of the things that you can do and get away with, for instance, under the 2010 Act, let's give an example of the conduct of a primaries. If you don't notify INEC, INEC does not observe, it has a consequence different from the consequence that there is right now under the 2022 Act. Because previously you can get away with it because, okay, all that the Act provided was for a penalty to be paid by the political party that omitted to do that. But now, not doing that will nullify the primaries.
Which has a significance to the
exactly.
very heart of the conduct.
Exactly, because without a primaries, you cannot have a candidate.
Which aspect of this law do you think will help guarantee the integrity of the results?
It's a combination of all the provisions of the law. You cannot take one aspect of the law and you know, credit it with that quality for being responsible for the credibility of the election. You have to take the totality of the law and apply it, because that is the intendment of every single provision in that act. It is intended, even from the very opening of the Electoral Act, that is the very intention of the law, so that every part of that act, every single part of it, from beginning to finish, and that is why even when you are interpreting a single provision, you have to do that in line with the provisions of the other laws.
So if you look from especially section 80 up to 84, 84 is particularly a very significant section, up to section 90, 91, 92, 93, and 94, and downwards in that manner. You see a lot of dramatic change from what we had in the previous electoral law. Now, this one has also touched on a very significant one that issue in relation to what happened in some states where electoral officers announce result under duress. There is a specific manner in which this new electoral law has dealt with it. You think that in some way will safeguard the life, the role, the integrity of the electoral officer, and in fact the integrity of the process, do you think?
Absolutely. Absolutely. I believe so. I believe so, because if under the old act, situations like that happened, and political parties or individuals that were associated with having to compel an electoral officer to announce a result or to do something under compulsion, under duress, we get away with it because of certain loopholes or certain gaps in the law. That has been taken care of. Of course, that also would help in not only safeguarding the life, because it means that if you do that, you are not going to get anything. So why do you have to start again? Why do you have to start at all?
Yeah.
And then if you even do so, you are not going to get the benefit of what you have done. So to that extent too, that to a very great extent, it will also help in the integrity of the process. It will also help in shaping the conduct of those who are participating in the election. Now he's telling you, look, you don't even have a chance to get anything, except the fact that you are interested in the criminal aspect of what you want to do, but it's not going to give you any result as far as the elections are concerned. So there is no incentive for anybody to do that. And that is what we see in...
Leonard Silk, it seems Nigerians have forgotten a particular era in our election, where perhaps one of the most popular phrases or words used is ballot stuffing, ballot snatching, scattering of the ballot. I mean, as recent as 2015-2019 election, that was very rampant. You see someone just stumbling, just going into the polling center, disrupt it, stop the ballot, and force them to announce the result. But if you look at what happened in Edo, Ondo, a gradual change began to emerge. Yeah. And we saw, I'm not sure I heard anything as ballot snatching. It has become very unpopular. What's going to be your commentary on that kind of scenario?
Yeah, so you see, when you snatch ballots, what you are likely going to do is to go sit down somewhere and print the ballots, right? Bring them, stuff the ballot box, and send it to the polling unit. Of course, the electoral officer is under some sort of situation. He does not have an option. He has to accept it, you know. And unless there is some sort of proof, which is an allegation of irregularity, you have to prove. The threshold is so high, you are not able to prove that. But now it becomes uninteresting. It's not attractive. You know why? Because technology is deployed to know, okay, this multiple thumbprint. We know that it wasn't Mr. A that did it, and we can find out who thumb-printed all of these things, if that person even happens to be in the database of INEC. So it becomes a disincentive for anybody to do that. And the strict provisions under this new law concerning serial number of ballot papers, because what people did previously, if you snatch a ballot box, or sorry, ballot papers from one polling unit, you dump it in another polling unit. But this law, and it has always been the case that the serial number of ballot papers must be identified to a particular unit.
And the color coding also.
Everything has to be identified. So it's like that's really part of the credibility of the process.
There is an improvement in our electoral process?
For every naira, even though it is scarce now, there is no naira note that has 2 serial numbers. One has to be a counterfeit. So also is the ballot.
So it's traceable?
It's traceable. It's traceable. And now there is a form that you have to fill. It contains the serial number of the ballot papers.
Do you feel a sense of a good development in our electoral process?
We have actually evolved. We are not where we should be yet, but there has, I mean, you just identified it. We have moved from that place where people are actually gearing and waiting to do that sort of thing. But it's no longer in the vocabulary of
Because if you do it, you're just wasting your time.
You are just wasting your time.
The result is already somewhere, uploaded somewhere.
Exactly, and we have a means of knowing what happened. So why waste your time?
And the law is also clear. You do that, you have made a mess of that, it's going to be cancelled.
It's going to be cancelled.
So, I mean, generally, how would you assess the preparations of INEC in a general outlook?
I tell you the truth, I had cause to say this to the chairman when we paid a courtesy call to him. Under his leadership, he has done a lot, in my own view, to earn the confidence of Nigerians in the role of INEC in conducting election. And that is very, very key. That is very, very important. Because if, as the electoral umpire, the public for whom you conduct this process do not have confidence in your ability to deliver sincerely and honestly, then it leaves a very huge gap. It becomes a problem. That means for every result that is turned out by the act of INEC, there is going to be a contest. But so I believe that that has been achieved by the leadership, and what INEC is doing, of course, is not him alone. It's everyone that is working with him, bringing their hands together to do this. He has enjoyed that, and I believe they are prepared. They are prepared. I was at the signing of the peace accord, and he was very confident to declare to Nigerians that they are ready, and that their loyalty is to Nigerians, their loyalty is to the people of this country and to the constitution of this country. And I believed him when he said so. When
any system has the confidence of the people, without any force or any kind of extraordinary attention, the system will work. Sorry. And I hope that tomorrow's exercise will just go smoothly. Let's bring this conversation home. Just about 2 or so questions before we wrap up. How impactful, or what are the implications of the CBN policy on the naira note and the scarcity of those notes? How impactful, or what the implication do you think it could have on voter turnout tomorrow?
Well, this is a tricky question. There is currently pending a matter in the Supreme Court. Different views have been expressed. If you permit me, I'll only tell you what we did as NBA. When we saw that policy being implemented, we consulted widely with stakeholders, people that deal mostly with Nigerians in the informal sector of the economy. The National Union of Road Transport Workers, the National Union of Road Transport Owners and all, and Rice Farmers Association of Nigeria. We went to Anambra, also the Association of Traders, and we got their views. We took the views of ICANN, we took the views, and we sat down and looked at it. And I said, well, these are the views of Nigerians. What should we do? We wrote to the governor of Central Bank, looking at provisions of section 20 subsection 3, and we noticed in our own letter that all the information, all the public notices that were issued with respect to the Naira design, there was no specific mention of what happens after, at that time, the 31st of January. That is, what happens to the notes after they have ceased to be legal tender. And we said there aren't sufficient information out there in the public. And because of the shortness of time, people are becoming agitated and there is panic in the system. So it is important for a notice to be pushed out there to let the people know that even though these notes will cease to be legal tender, but there is a provision in the law that says that I have a right to come to CBN, make a demand, and that note would be redeemed by me. It's a statutory obligation. We did that, wrote to the central bank. We also sent that same letter to the Minister of Finance. We paid a courtesy call on the Minister of Finance. We wrote to the CBN to ask for that courtesy call. We haven't gotten a response as yet, but we saw the minister and we spoke to the minister about it, and that this is the position of the Nigerian Bar Association. What were we doing? As a bar, we believe that we have the responsibility and with all Nigerians giving direction with respect to matters of this nature. That is what we did, and I would request that you permit me not to go beyond this with respect to the issue of Naira redesign, whether or not, but it's obvious that people are facing hardship.
But could it affect voter turnout tomorrow?
Well, if I don't have the Naira to move from point A to point B, and I know that there are people who suffer hunger as a result of this, then perhaps there may not be the motivation for me to even step out and vote. But that would depend on the individual experiences in this regard.
My final question perhaps would be on my interview with the EFCC chairman about 2 nights ago, and who said, I was asking about the arrest they made in Ekiti and Osun State for those who are buying votes, allegedly buying votes, and there is another 32 million or thereabout that was seized in Lagos today, allegedly meant for vote buying. When I asked about the prosecution of these people, he said there were some issues they had in court, and because according to him, there were no fiat from INEC to prosecute that matter. That is a bottleneck, and it comes to the issue of electoral offenses and how such is going to be prosecuted. There are those who believe that there might be a huge vote buying in tomorrow's election. What would you suggest is a way to deal with this situation as far as our laws are concerned?
Well, so being found with money, and there are several things that that can amount to. Suspicion that you are buying votes, and also some other offenses that may arise from that particular conduct of the person that is found with that money. I think what I would advise is to just look at the provisions of the law and situate what the law has provided within the context of what the person has done. And if that amounts to an offense, because before you can take anybody to court, that particular act that you are accusing him of must be one that has been made an offense by law. There must be a law somewhere that said that is, if you do this, then it is wrong. Otherwise, you can't even prosecute that person. That is a constitutional requirement. So you go to the laws. What has this man done? Is it an offense under this law? What has this law provided? Who has the power to prosecute? How is this prosecution to be done? Before which court should that person, which court has jurisdiction? I think it's very easy for us to know exactly what we'll do with respect to the things that we have found that Nigerians or any Nigerian has done, which we believe is contrary to the provision of any law. So you don't leave it to just your whims. You look at the law and find out exactly what the law has provided. If the law said that this offense or describe the offense, you take that that person before the court that has the jurisdiction to deal with that issue, and that would be my suggestion in this regard. But I should also say that the Nigerian Bar Association condemns vote buying. It is wrong, it is illegal, it is unlawful, it is something that is going to impact negatively on the electoral process. We condemn it, we are completely opposed to it, and we said to the INEC chair that the Nigerian Bar Association is prepared to partner with INEC in whatever way to support INEC in making sure that matters of this nature are dealt with, and in whatever way too that the Nigerian Bar Association can support INEC to succeed in delivering a free, fair, credible and verifiable election. You can count on the Nigerian Bar Association, and that is what we are doing. We are putting together a team to even offer pro bono service for INEC in this regard, to offer pro bono service.
Yeah.
And that's because we are changing the mindset, not only of lawyers, even the perception of the public on lawyers should begin to change. We shouldn't just be reputed for how much money we charge for the cases that we do. We should begin to be seen as those who chart the course for the people. Because if you remember, and I think I mentioned it either with you or one of your colleagues, I said it was Sapara Williams who said that the legal practitioner lives for the direction of his people and for the advancement of the cause of his nation. For lawyers to participate in this process pro bono, it is living for the advancement of the cause of this nation. A cause that is noble, a cause that is going to bring benefit to every Nigerian, a cause that is going to be responsible for the growth of our political, our polity, and also the growth of our economy. And we're offering direction to the people. That is exactly what we did with the letter we wrote to the CBN. I mean, that's our role. That is, we want Nigerians to begin to have that understanding of the role of lawyers, and we want lawyers to also step out and be who they truly are. The primary responsibility of a lawyer is to serve his people and is focused on justice for the people, and that is what we are socio-economic change agents. Yeah. That is simply what we are preaching. That is what we want to be known for, and that is what we are primarily called to do. And we want to move from that place of abdication to the place of responsibility.
Do you think that Mr. Falano, one of your colleagues, was saying, talking about not militarizing the election, or not, we shouldn't have a militarization of our election if you consider the number of deployment that we are having? Do you have that feeling that maybe even the armored tanks that are staying on the streets of some parts of Nigeria, do you have the feeling that maybe we are over-deploying, or there is militarization of the process?
Within the peculiarity of our situation, I do not think so. I do not think so. Much as I agree, we shouldn't militarize the process. But given the experiences of Nigerians in this country, it becomes, I think, necessary for such deployments to happen. Look at the killings that are going on. Look at the gentleman who was killed in Enugu. You know, he was just coming back from campaign. He was killed. The vehicle, I think his body was burnt along with others together with him. You know, that is despicable. That is barbaric. I mean, we've seen cases where, for instance, judges who just stepped out of court were shot dead. You know, Nigerians are being maimed left, right, and center. Properties are destroyed, if only for the purpose of securing the lives and properties. These deployments are made so that we can get, you know, some sanity in the system, you know, to allow for this process to go on. I mean, that should be allowed.
All right, thank you so much. Do you have any toll-free number or any number to call?
Yeah.
Should there be any issue?
We have a toll-free number. The number is 080-0333-1111. So 080-10-333-111.
Okay. So for those who see something and they want the intervention of the NBA, they can call these numbers.
Call this number. We'll be there until these elections are concluded. We like you said, we have such a wide reach, to 128 branches across the country. 36 states. 36 states with FCT. And you can see my hat. I belong to the Abuja branch.
Abuja branch.
We are all geared up and ready for this election to observe. And what we are doing is to make sure that whatever we see, we report. And whatever Nigerians see, we urge them to also report, call us. We will take up those complaints and we will deal with them within the remits that we are allowed to do. Sure.
The president of the NBA, Mr. Maikyau, thank you so much indeed for coming, and I wish you and your colleagues the very best. Should you find something out, we would like to have you back to review the process, since we're having a preview of the election on the eve of election. Thank you so much indeed.
Thank you so much,
I appreciate it. It's good to see you again.
Thank you.